morning, everyone, and welcome to this second meeting, the second coffee talk about Law 132, which is the enabling law on artificial intelligence published in Italy in September 2025. In the previous meeting, we analyzed the general structure of the law, some general principles, and we highlighted that it deals with the use of artificial intelligence in specific sectors, and that it governs and regulates the institutional bodies at the Italian national level that will manage the implementation of the IACT and of this law 132. Today, we will start analyzing what the law provides for in specific sectors, beginning with the healthcare sector. In the next meetings, we will then cover research and artificial intelligence in the workplace. We will go through all the sectors that are addressed and have specific regulations in the law. So now I will share my slides. As I mentioned last time, as I had already anticipated in the previous meeting, these sessions are available both in Italian and in English. This is why we have slides that are, let's say, split in half in both Italian and English. I want to clarify for transparency that the English translation is done with the help of an artificial intelligence tool. So this is obviously my profile, the part in Italian, and what you see in gray is in English. Many of you probably already know me. I have been working with technologies for many years. I'm an expert in healthcare law. I have always dealt with organization in the healthcare field. And for many years now, I have been focusing on new technologies, particularly their application in the life sciences sector. Now, let's get to the topic of our day, which is Article 7. Which is specifically titled Use of Artificial Intelligence in Healthcare and Disability. So the first principle of the regulation, the first paragraph, states that artificial intelligence can only be used for the purpose of contributing to the improvement of the healthcare system, meaning the organizational system, or for prevention, organization, and treatment of diseases. It may seem a bit obvious, but the general principle is that artificial intelligence, of course, cannot be harmful. In other words, it must be used for the benefit of the patient. Naturally, this use must take into account the freedoms and interests of individuals who, in the specific case of healthcare, are patients, including matters related to the protection of personal data. This means that when using an artificial intelligence system, the party using it, so it could be the public administration or even a doctor in their private practice or public entities themselves, meaning regions. At the national level, the Ministry of Health, Agilas, so all those who in some way use artificial intelligence for healthcare purposes, but also for other purposes. Organizational must obviously comply with the general principles of data protection. On this topic, our Italian Data Protection Authority intervened in September 2023 with a set of 10 guidelines that you can freely download. I believe there is also an English version, by the way, from the authority's website. The set of 10 guidelines contains 10 points, and these 10 points, in a way, retrace the main aspects of implementing data processing. So you see the definition of the legal basis for processing, the principles of accountability and privacy roles, meaning who is the data controller, who is the data processor, which is always a bit more complex than it seems, and even more so in the context of artificial intelligence systems. Then knowability, meaning transparency and non-discrimination. These are more like principles that are also present, albeit a bit more subtly, in the GDPR. Obviously, there is an obligation to conduct an impact assessment given the potential impact on the rights of the data subject. By the way, the IACT, I'm perhaps anticipating topics we'll discuss at another time, specifically provides for an assessment, the so-called FRIA, that is the assessment of the fundamental rights of the data subject. Then data quality, integrity and confidentiality, fairness and transparency, human oversight. Human oversight is obviously the obligation when using an artificial intelligence system to have a human being who supervises, who therefore monitors the functioning of the system and can also directly intervene in the AI system and stop it. Attention, this is very interesting because this provision in the Code of Conduct from the Data Protection Authority finds its precise legal reference in Article 14 of the AI Act, which stipulates that artificial intelligence systems must be designed. and then placed on the market with a design that allows people to clearly perceive what is happening and also enables humans to intervene in the system, in extreme cases, even to stop it. So, including a stop button. The law doesn't state it exactly like this, but that is the meaning. In fact, the AI Act does mention a stop button. So you can see how, let's say, in some way, the data part then becomes interconnected and linked with what is set out in the regulations of the European regulation on artificial intelligence. This is the measure adopted by the Data Protection Authority. It serves as a sort of guideline and is very interesting. So I definitely recommend reading it to make sure that when you use an artificial intelligence system, you are actually in some way complying with Article 7, also regarding data protection through a tool provided to the authority. I have another extremely important document for you, in my opinion. This one came out about 10 days ago. Sorry, I didn't include the reference. I didn't put the date on the slide, but it has just been published. This, on the other hand, is a European document, specifically from the European Data Protection Supervisor, which clearly explains how to use generative artificial intelligence and more precisely how to ensure proper data protection when using generative AI. So this is particularly interesting because, as you all know, the European regulation on artificial intelligence has its own timeline for coming into effect. It has already been published, of course, in August 2024, but its effective dates are spread out over time, also due to the impact that this regulation will have. The first part that came into force, the one concerning definitions and streamlining, will be in February 2025. But on August 2nd, 2025, so 4 months ago, the part concerning generative AI came into force, or rather became fully effective. So generative AI that is being introduced to our market for the first time today must already comply with the provisions of the IACT. So this document is from the European Data Protection Supervisor. So it doesn't deal with the product itself, but rather with the processing of data related to the use of the product. However, it does in some way answer all the questions I have mentioned to you. Obviously, we don't have time in this session to analyze them. There are 2 slides, this one and the next. We obviously can't go into them in detail, but I can assure you that they are very interesting and also, let's say, instructive. They really help you understand how to use it. Thank you. The AI system. Obviously, this doesn't specifically concern healthcare. It generally relates to the use of AI. However, of course, this also applies to the AI that is already being used within healthcare facilities. This is the second slide. I left them in because for this series of coffee talks, we decided to create these slides and allow everyone who is interested to download them directly from our website. So I've included all of them, even if we can't comment on each one, because I think they're very interesting. The second part of Article 7 concerns the use of artificial intelligence still within the healthcare sector, but particularly with regard to access. The regulation states that the introduction of artificial intelligence systems in the healthcare system cannot select or influence access to healthcare services based on discriminatory criteria. This regulation, too, in some way ties back to the rules set out by the AICT. You will surely remember that the AICT, as a legal framework, distinguishes between low-risk AI and high-risk AI, with the latter also requiring a more complex process of testing and validation. In particular, high-risk AI systems fall, within this notion of high-risk AI system, including all products subject to other harmonization directives, such as medical devices when they have a notified body. Then in Annex 3, it instead provides for high-risk AI systems that are not legally classified in Europe as devices, diagnostics, machines, or other types of vertical products, but are software that in some way operate in certain contexts that are considered inherently dangerous. In particular, among these contexts are education, workplaces, and other similar settings. Specifically, there is also access to essential levels of healthcare. This second paragraph obviously ties back to this provision of the AI Act, which, among other things, will become fully effective in August 2026, so let's say. In August 2026, we will already have systems in place. At the moment, an AI system is put on the market. This AI system will be considered high risk and will already have to comply with all the requirements of the AI Act. And therefore, intrinsically, that is in its very design, it should already not allow for discrimination. Clearly, right now, we still do not have software subject to the AI Act regulations to verify whether, for example, if I have an AI system for managing waiting lists or for the emergency room, in order to comply with this article, specifically the second paragraph of Article 7, I would actually already need to check how the system works, request information from the provider, and verify, let's say, by actually observing and even conducting operational tests, specifically on the system to see if it creates any discrimination, and if so, obviously take mitigation actions if the system was not properly trained because there were no regulations yet, or perhaps because it was put on the market a year or two ago. Therefore, it is necessary to implement internal procedures to mitigate this bias, this discrimination. Then we have another one. The third paragraph concerns the important requirement to clearly inform the patient about the use of technologies. Now, this is certainly a very challenging regulation. As far as Italy is concerned, it requires modifying in some way the information notices that are issued and consequently also the process of obtaining consent. The information notices are issued according to Law 219 of 2017, which in Italy requires the obligation to obtain consent, obviously after providing information about the treatments. This regulation is very sparse in terms of its scope, because the first question that obviously arises, and to which honestly I don't know the answer, is how extensive this information should be. That is, do I simply need to explain that I am using an artificial intelligence system, for example, to review diagnostic images in a broader and more comprehensive way? Or do I actually need to go into the details of how this system works? What exactly do I need to say? Because too much information is probably unnecessary and risks being counterproductive. Too little information risks being insufficient. So the regulation is not particularly clear or straightforward. At this stage, we will see if some interpretation will come out from the authorities at a central level on how to interpret and apply it in some way. It's a regulation that, in my opinion, also opens up scenarios that could be problematic, because if I tell the patient that in their care pathway, which is obviously supervised by the doctor, an artificial intelligence system is being used and the patient does not give me their consent, at that point, what do I do? Do I not treat the patient? Do I have to have at the same time a treatment process that does not involve artificial intelligence? It's not, what I mean is there's a legal issue here, an issue of interpreting the regulation and therefore understanding what exactly to include, how broad it should be. And then there's also, if you will, a practical and operational issue. Section 4, paragraph, this law promotes the development and study of the dissemination of artificial intelligence systems that improve the living conditions of people with disabilities and facilitate accessibility and mobility, regardless of autonomy, safety, and inclusion processes. So this is a provision, what is called a programmatic rule. The part you see below, the one in italics, is the actual rule, and what you see underneath are my comments. So what does this basically mean? First, that those who design must do so with consideration, obviously depending on the artificial intelligence system, for those who will use it, and must of course take into account possible situations of disability. Those who purchase on behalf of the public administration must do so taking into account possible disabilities, and therefore, even at the level of public tenders, must verify the potential participation or give preference to those who offer products with better accessibility. Clearly, there is also the issue of training healthcare professionals and other users so that they can make the best use of these products. So it is a regulation that in some way aims to ensure that those who may have disabilities are not left behind, indirectly obligating, but this is also present in the IACTA, a design approach that takes possible disabilities into account. Fifth paragraph, artificial intelligence systems in the healthcare sector serve as support in prevention, diagnosis, treatment, and therapeutic decision-making processes. But the final decision always remains with healthcare professionals. So we already mentioned this earlier, and we'll see it again. This is obviously one of the key principles of the entire artificial intelligence system and also of the IACT. Artificial intelligence does not replace humans, but is absolutely an artificial intelligence. In human activity, the final responsibility and the final assessments always ultimately rest with the human, in this case, of course, with the doctor. Sorry, someone called me in the meantime. So what needs to be done beyond this very nice principle, which we all surely agree on? What actually needs to be done internally? Well, in my opinion, the first thing that should be done immediately is to start mapping. Today, we have the legal definition of what artificial intelligence is, which is, of course, in the AI Act. So what needs to be done is definitely to map the systems that are already in operation within healthcare facilities and that fall under the definition of artificial intelligence, and to start providing training, of course, to the people who use them. These systems, and to establish internal procedures that must in some way provide for their use by appropriately trained individuals. And as I mentioned, their use also in connection with Article 14. However, this article is part of those regulations that will only become fully effective in 2027. Still, it ensures that humans will in some way have the ability to intervene. The peculiarity of this entire set of regulations, including the Italian ones, which in some way are based on the European framework, is that we truly have a circular system here. That is, it's not just an obligation for the provider of the artificial intelligence system, but also an active obligation for the user, who in our case, in the healthcare sector, is the one using the system. Last slide, sorry, sixth to last slide, because this is the last paragraph. AI systems used in the healthcare sector and the related data employed must be reliable, periodically verified, and updated in order to minimize the risk of errors and improve patient safety. So here, obviously, since it is a circular system, it is a system that starts from the design phase and continues all the way to its use, to monitoring its use, to improvement, to feedback that may come in. There is obviously a post-market surveillance system by the suppliers in collaboration with the users, so an improvement, of course, of the system itself. So here, the regulation, in my opinion, is essentially trying to say two things. The first is that the system must be monitored. It's not written, in my view, in a very clear way, but I see it as having a dual meaning. On the one hand, it's certainly about the proper functioning of the system and the possible notification to the supplier when the system does not work. Attention! The second point concerns the data entered. That is, an artificial intelligence system works well if the input data is correct, which means that whoever uses the system must obviously be capable and pay due attention to entering the correct data. Just think, for example, of something we all do nowadays: writing a prompt in generative AI systems. So this system that needs to be put in place, as we mentioned in paragraph 5, that is training internal procedures for its use, and also provisions for the possibility of intervening in the systems. It is completed, of course, with oversight, checking whether what has been done is correct, whether the person is properly trained, whether the person actually using it is using it correctly and entering the data properly, because artificial intelligence can obviously make mistakes, but it is much more likely to make mistakes if the data entered is not correct. So this system, of course, is a system, like all quality systems, of risk analysis and quality that is circular in nature. Thank you all. I hope you enjoyed this talk about the healthcare sector. In the next coffee break, we will look at the new developments in scientific research, which, to be honest, are many and also very interesting. Have a good day, everyone.